Hi, welcome. This is Judah Z, founding partner with Peters & Associates PandA Law. Thanks for visiting our channel today. Today we're going to just talk about some common legal issues that I've come across over my 20 years of practice that clients come to me often with, right? So we're going to talk about when you start a business, how to start it, what's the benefits of it, and how do we protect our personal assets when we're in that business. Number two, we're going to talk about what to do if we have debt arising from a rental property, right? So we moved out of a rental property. They're coming after us for past due rents or damage. What do we do there? Number three, how do we protect our home from foreclosure, right? We don't want people coming in and losing our home to foreclosure. Now, a lot of times people will say, well, Judah, why do I need to talk to a lawyer? I can just Google this stuff and find out all the answers. Yeah, but Google can often misdiagnose the problem and misdiagnose the solution and how we get there. So you should really talk to a lawyer about these things. You can think about it like when people get sick, right? They have a cough, they go look at WebMD and they have the most rare deadly disease ever when they look it on WebMD and they freak themselves out. No need for that. Look, just talk to a lawyer, preferably one who can give you a free consult. They'll give you a good lay of the land, and then you can decide what kind of trouble you're in. But enough of that. Let's get into the details, and we'll talk about each of these subject matters. So we've often heard that small businesses are the backbone of America, and I believe that is true as a small business owner myself. But why do we even start a small business, right? Or how do we protect ourselves if we have a small business? Kind of the same question. So you normally start a small business by developing what's called an artificial entity, right? A business under the law with the state, right? So you'd go to the Nevada Secretary of State, you set up your business, and at that point, that business becomes an artificial person, right? Just like you or me, it's almost like you had a child, right? And the name of the child is ABC Business, and you started with the Secretary of State, so it's an artificial person. The reason why we do that is to protect ourselves personally. It's something called limited liability. So let's say that you have a house cleaning business and you're in someone's house and you're cleaning it and they trip over the vacuum cord and they hurt themselves. Right now, there's a whole bunch of other things that are going on here, but maybe that homeowner says, look, you were negligent in leaving that vacuum cord across my living room. I'm going to sue you for my broken leg. Okay, well, you don't want them to sue you personally. You want them to sue the business, right? And that way they cannot touch you. So that's the purpose of setting up a business, the limited liability. They can only come after the business. They cannot come after you. Now, oftentimes people will set up a business and they'll just think it protects them all the time, but that's not what the law says. The law says you actually have to treat that business as a separate person. It cannot be your alter ego, right? It cannot be just a side. I can't be Bruce Wayne and my business be Batman. Can't do that, right? It has to be completely separate person. Most of the time, people run afoul of that by co-mingling corporate debts with personal debts, corporate assets with personal assets. So what that means in very simple language is you can't have the business pay your personal bills. So the business can't pay for your home, your food, unless you're on some kind of business expense, things like that. And you personally cannot pay the business's bills. So if the business has an office somewhere and they pay rent, well, you can't pay that out of your personal account. Personal debts have to be paid out of your personal account. Business debts have to be paid out of the business account. If you want to funnel money out of your business to yourself so you can pay your personal debts, that's fine, but the business has to do a dividend or it has to pay you a paycheck, something like that. There has to be some kind of adherence to the formality of the business structure. Otherwise, you've created an alter ego and your potential plaintiffs in the future can pierce the corporate veil to come after you for your personal assets. So when you set up a business, just abide by the business. You have to treat it separately. You have to do the business bank account. You have to do all those things. When might you need a lawyer in this scenario? Well, maybe you need a lawyer to help set up the business in the first place. Go through the Nevada Secretary of State. I'm in Nevada, or your state Secretary of State, right? You're going to want to get an EIN number, which is the business's social security number with the IRS so they can pay taxes. You might need to set up an operating agreement for the business, all these things. So you might need a transactional attorney on the front end to make sure that you're protected and they can talk to you about how you preserve the limited liability. On the back end, you might need a lawyer if the business is getting sued or you're getting sued. So in those times, you might need what's called a litigation attorney, someone who can help you resolve the problem when it comes to that. So that's kind of how we protect ourselves and protect our business in a nutshell. But definitely, if you're setting up a business, go see a lawyer. If you have already set up a business and you have some business debt or a negligence claim or whatever it may be, talk to a lawyer at that point as well. Next common issue that people come to us with is rentals, right? So I moved out of my rental, I thought it was all good, and then later on, the landlord is coming back to me, or the property management company is coming back to me and saying, Judah, you owe $10,000, either missed rent or damage to the property, all of this, right? So how do we protect ourselves? First thing we need to understand, everything that governs that relationship with the landlord or the property management company is found within the lease itself. There's something called, if you want to know, it's called the parole evidence rule. What it basically says is only the four corners of the document matter, right? Nothing outside of that lease agreement matter. You might hear Judge Judy talk about it if you watch her talking about the four corners of the document. That's what she's talking about. It doesn't matter what you say to the landlord. It doesn't matter what the landlord says to you. They can promise you the world. Doesn't matter. Matters what's in the lease. So first, if you have a question about what you can do, what you can't do, how you move out properly, look at the lease first. Sometimes, and just an add-on to that, once the lease expires, it converts by de facto into a month-to-month rental agreement. Well, then what you have to do there is when you move out, you just have to make sure that you give at least 30 days notice, preferably in writing, especially if the lease calls for that, stating that you're moving out. And it's not within that month. You actually have to give it the month prior to count off the proper number of 30 days, right? So otherwise you're gonna be liable for that month and perhaps the next month after. So that resolves what to look at when you look at how to move out, right? Look at the lease first, give proper notice, following the procedure in the lease. Oftentimes though, people will move out and then the landlord comes back and says, this was damaged, you owe me thousands of dollars because of that. Well, how do we protect ourselves there? Number one, take video when you move in, right? Get a beforehand shot of what the property looks like inside and out. Take video, take pictures, the more the better. State on camera where you're at, what date it is, and you're taking video, right? Also, that landlord should have a checklist of what's damaged in the property prior to. Make sure that's signed off. Make sure you get a copy of that, okay? Because that sets the status quo of what it looked like when you moved in. Okay. Now, when you move out, you got to do the opposite, right? You got to do the walkthrough with the landlord, check off anything on the list that is damaged, right? And normal wear and tear is acceptable in most states, at least in Nevada and most states that I know of. You don't have to pay for normal wear and tear. So, the carpet's damaged to a certain extent by you just walking on it, right? It needs to be repainted. There's some minor chips here and there. All that stuff, light bulbs, right? All that stuff is wear and tear. Now, if the carpet is ripped up or if there's mold throughout the apartment, right? Holes in the drywall, that's not normal wear and tear, right? But those are the things that need to be recorded when you move out. So once again, make sure it's on the checklist, make sure that you and the landlord agree to those damages. And then also take video and pictures once again. Here's the damage. So that way, if the landlord ever comes back to you, you can go to the judge and say, no, judge, look, this is before, this is after, just normal wear and tear. Okay, so that's how we're gonna normally protect ourselves from that kind of claim. Also, in certain states, the landlord has only a certain amount of time to do this walkthrough. Like in Nevada, I believe it's 30 days. After move out, they have to do it within that time and give a refund of the security deposit within that time, only minus normal wear and tear or what you agreed was the damages. If they don't do that, if they don't refund that security deposit within that time period, let's just call it 30 days, there's often a legal penalty. In Nevada, I believe it's double the amount of the actual security deposit. So there's a time period where that landlord can just not hold on to that money because you need that money to perhaps re-rent another place. When to get an attorney in this place? Well, I don't think you need an attorney at the time you're signing the lease unless you want to be just very precautious, right? Or if it's a very intricate lease, you might want to just so you fully understand it, but definitely take your time to read it. Most people don't even read the lease. On the back end, if the landlord says now you owe money or you're dealing with a collection agency or you're getting a lawsuit, definitely hire a lawyer at that point, hopefully before it goes to lawsuit, because we can normally resolve those kinds of debts for pennies on the dollar. Last topic we want to talk about. Let's say that you're not a renter, but you're a homeowner. How do you protect yourself from foreclosure? Okay, so a couple things we need to talk about here. Number one, understand that every mortgage on your property, whether it's a first mortgage or a second mortgage or a third HELOC home equity line of credit, these are all liens on the property. And all of those lien holders, mortgagees, have the right to foreclose. Now, whether they will foreclose or not just depends upon whether there's equity in the property, right? But understand that the second lender or the second loan can foreclose without the first loan's permission. All they have to do is when they do foreclose, the first money goes to the first loan, whatever's left over goes to the second loan. Now, we haven't seen a lot of that until recently, the past couple years, because all these homes that were so underwater during the Great Recession, '08 to maybe 2014 or so, have now gained enough equity, at least in Nevada and a lot of other states, where those seconds that were underwater, where the home value was less than what was owed on the first loan, now have equity because the home is worth way more than on the first loan. So those second lenders are now coming out of the woodwork and they're trying to foreclose. They're called zombie seconds. You might hear this term. Often, too, not only the original lender doesn't have that second anymore, now they sold it on the secondary market to someone who bought it for pennies on the dollar, let's call it 10 cents on the dollar. But when they try to foreclose, these zombie seconds, they're not just hoping to get their 10 cents on the dollar, they want the whole dollar, right? So they're gonna go after it all. And they can foreclose, and a lot of people don't think they can. And so that's a definite situation where you need to come see a lawyer if you get any kind of zombie second popping up out of nowhere, right? Because it has to get resolved, either through a bankruptcy or through settlement or loan modification. All those things can be done on seconds. It's just a little bit more difficult to do. And you definitely do not want to try to do that on your own, because these seconds can be a lot more aggressive because, they bought it for pennies on the dollar, and this is how they're going to make their money. Who else can foreclose on the property? HOAs can foreclose, right? The state can foreclose for property taxes. These kinds of things you don't want to mess with. Oftentimes they have what's called a super priority lien. That means they can foreclose and they're going to get paid first before any lender. So remember when we were talking about the zombie seconds, right? They have to pay the first lender first. A lot of times HOAs and the government doesn't have to pay the first lender first. They can just come after you, get the money first, and then the first lender gets the money after that. So sometimes what you'll see first lenders pay that out of pocket because they don't want the county or the HOA to foreclose, but then they're gonna add that into your mortgage balance, and now you're paying interest on that as well. Now that might be okay with you, but just understand that. So those are kind of like inside creditors to your homes. There's outside creditors too. Let's just think of like a credit card. Let's say that you default on a credit card, they sue you, they get a judgment against you. They can take that judgment and attach a lien on your home. And then they can foreclose on that home, right? Same thing, they're like seconds, right? They have to pay off all the senior lenders, lien holders first, but still there's a lot of equity in these homes. Perhaps they're gonna get their money from there. Now, how do we protect ourselves against that? In a lot of states, there's something called a homestead, right? You would file a homestead declaration with the county recorder in the county you live in. So in Nevada, I live in Las Vegas, that's Clark County Recorder, right? We go to them, we record a homestead declaration, couple page document, costs around $45 to record. You don't need a lawyer to do this. You can do this on your own. Maybe look up some YouTube videos on it. Maybe we'll talk about it later. But you definitely don't need to pay anyone for that. Now, what does the homestead declaration do? I'll give you an example. In Nevada, if I don't have the homestead declaration, only about $189,000 of equity is protected against an outside creditor, this credit card company, coming in to foreclose on my property. So if my home is worth, if it has equity of $300,000, so fair market value minus any loans on the property, if what's left over is $300,000 and I don't have a homestead, I can only protect $189,000 of that $300,000. So if I have a $50,000 judgment lien on my property, that judgment lien holder can come in and foreclose and get their full $50,000. Now, in that scenario, I had $300,000 in equity, right? They're going to come in foreclose. The first lender gets paid what they get paid. Of that $300,000, $50 goes to that credit card company, and I get $250. Okay, so what does the homestead do? The homestead in Nevada, at least, increases that amount from $189,000 to $605,000. That's a big difference. So most people don't have $605,000 of equity in their home. Once again, defined as fair market value of the property minus any liens that are secured by the home, mortgages, HELOCs, things like that. So most people don't have $605,000 of equity. So you're going to protect your home from foreclosure against any outside judgment creditors that put a lien on your home. So that's how we protect ourselves in that kind of scenario. Now, if you're getting a lawsuit with a request for foreclosure, you definitely want to see an attorney at that point. A lot of these HOAs, a lot of these county governments, trash services, utilities, they don't want to foreclose. They want to work out something so they can keep the homeowner in their home. It's just not good PR for them. It doesn't look good for them. But at any time where you see something like that, you're definitely going to want to talk to a lawyer. So Thanks for taking some time today. The things that we talked about today is, well, how do you protect yourself and what are the benefits of having a business and some kind of business entity to help you with that, right? What do those procedures look like? Number two, how do you protect yourself from getting hit with an unseen rental bill after you move out, either for rent that you didn't supposedly pay or for damage to the property? And then three, how do you protect yourself against foreclosure in your primary residence as opposed to investment properties? If you enjoyed the video today and this content, you'd like to see more, please like and subscribe, and you'll see a lot more of myself and PandA Law, and we'll talk about more exciting topics in the future. Thanks for your time.